Last month, the quiet neighborhood of Ggaba became a makeshift court. Under the watchful eyes of a grieving community, Okello faced the ultimate penalty. For many, seeing justice served where blood was shed brought a sense of closure. Legal officers say the ingredients of Okello's case were straightforward, which made the path to a verdict in the given environment a lot easier and much faster.
He was caught with his weapon. There was not much to investigate. And in his defense, he did not raise a lot of things where one would say that maybe, no. He just said that he had a problem with his head. And I don't think it did convince court that actually he did not know, because the purpose of pleading insanity is to show court that I did not understand what I was doing.
However, speed comes with a price. While mobile courts are being hailed for reducing the massive backlog in conventional courts, several lawyers are raising red flags.
There was a miscarriage of justice in this matter, and anyone will tell you that it would be very easy for the decision of Ggaba to be overturned on appeal because of the procedural flaws. For example, if someone raised a defense of insanity, like he did, that alone would take time to investigate. It cannot be rushed. It is so technical that the decision cannot be rushed on whether someone is of a proper mind, state of mind. First, at the time the offense was committed, and secondly, even during trial.
They argue that the theater of a crime scene creates an environment of intense pressure for the judge, the lawyers in practice, witnesses, as well as the accused.
Advocates or the lawyers involved. Professionally, we have a right to practice. That's under Article 40. But the environment, when you're seated or you're practicing in such an environment, you can't be comfortable to do your work effectively as you would have done if it is in the court premises. Because one, the public is always hostile. We saw it. When they read the charges to Okello, the public was busy echoing. They are reading out someone, did you commit? And says, I didn't commit. I said, no. So, like, the public lacks sensitization on what the proper procedure under the law is and what rights are entitled or they are supposed to be granted to the accused person. So for them, they are there to echo. And that affects even you, the lawyer. We are not accorded security. When security is given there, it's for the judge. So me as a lawyer, the public basically looks at me as someone who is defending a criminal. I'm supporting a criminal. That's the public judgment, because they know once a lawyer has come in that matter, is supporting this criminal. He's saying the man didn't kill, yet we know he killed. So that judgment is always that it affects your proper preparation and presentation of your case. The other thing is the judicial officer is also at a test, because like I said, the court is seated, the public is echoing. Even a judicial officer, whereas they should have stated something that is within the ambit of the law, because the public is putting pressure, they have to succumb to that pressure.
Despite these concerns, the consensus is that mobile courts are a vital tool for accessibility to justice. For those in remote areas, the distance to a conventional court is often a barrier to justice.
We have jurisdictions and districts where the high court or court is far from the people or witnesses in any matter. If you bring the court closer to the people, it facilitates first expediting the matter, because one of the reasons for mobile courts is to expedite for a speedy trial, where you would have matters where you miss witnesses and have to adjourn. If you go closer to the people, then you bring justice closer to the people.
These capital offenses, they take so long. People have spent on remand 7, 10 years without being tried. And just like it has happened in the Okello matter, which we would applaud them for, we would pray that the same doesn't stop. Let it go to other cases We have seen political cases. We have political prisoners. Cases are adjourned year in, year out. There are people who were arrested in 2021. Like I would give you some of the political prisoners, Macheta and whatever, who were arrested in Kalanga. Up to now, they've never been tried. They are still in prison languishing. So we are saying the judiciary should not have cases of isolation that they select for that speedy trial and leave out others.
They suggest that these courts should be prioritized for petty crimes to decongest Uganda's flooded prisons, where a cell that is supposed to hold 40 people has about 200 people.
Now, if you have community courts and if we invest in them, because they need real investment, if we invest in them, there's those small cases which can be handled even in a single day, where we should not take someone to reserve for 2 weeks or even a month or even months. I think we should explore that direction and have very many of those community courts in transactions of that nature which are not very complicated.
For now, the Okello case sets precedent to the efficiency of the mobile court system. But as the gavel falls, Ugandans must ensure that in the rush for efficiency, they don't sacrifice the safety and independence of the justice system. BEATA MUWEMA, NTV.